Okay, today is Monday, April 29th. This is Children and Justice, and last week we began learning Module 7, which discusses the issue of confidentiality in child protection and in the justice system when it comes to children more specifically. Before we pick up where we left off, I want to talk about something that I neglected to discuss when we were talking about investigative interviews and general investigation issues, and that is video recording of children's interviews. Now, a few years back in Passaic County, New Jersey, one of the interviewers that you may see, I don't know how many clips or if any I use in this course, but in the forensic interviewing course I use a lot of clips. Some of them include the forensic interviewer who works with me, Giselle Enriquez. And Giselle did a forensic interview of a child, and during that interview there was a technological malfunction. The recorder didn't record. So I instructed Giselle to immediately take or create notes and then to write a report to memorialize her recollection of what happened during the forensic interview. Now, eventually that case wound up going to the Supreme Court. And the only way it could go to the Supreme Court is if there was a conviction. As you all recall, that when there is no conviction, when someone is found not guilty or acquitted of a criminal offense, that's the end of it. There's a constitutional provision that is implicated when someone is acquitted, which says you cannot try someone again. Can someone tell me what that constitutional provision is? Salud. Huh? Nice. The double jeopardy clause. Correct. Well, in this case, that wasn't involved. The man was the man was convicted. He went to the appellate division, and this case later went to the Supreme Court. And the issue that was front and center among many issues that he brought up on appeal was whether we did the right thing when the technology malfunctioned. And the defense was arguing that that the interview should have been recorded, and the fact that it was not recorded prevented us from prosecuting him, at least based upon what was said during that interview, that all interviews should be recorded, that is a mandate, he argued, among other things. And the Supreme Court wrestled with that issue, but it was an issue that was over rather quickly, if you ask me. This was not something that was done purposefully, number one. Number two, there is no mandate in New Jersey that that forensic interviews must be video recorded. And in fact, the leading case on this issue is called Idaho versus Wright. It's a United States Supreme Court case. And it's a Supreme Court case that talks about children's hearsay. Remember, we talked about the tender years exception to the hearsay rule. And that allows children who are under 12, who make a statement about sexual abuse, not physical, sexual abuse upon themselves, it allows those statements to be admissible in court despite the rule prohibiting hearsay generally. The Supreme Court case that allowed that, the United States Supreme Court case that allowed that was called Idaho versus Wright. And it allowed the tender years exception, not only in New Jersey, but throughout the United States. We codified it or created a rule. You don't have to remember the number, but it's called Rule 803, little c, the number 27. What I've been referring to as the tender years exception to the hearsay rule. So many states adopted a similar hearsay exception, and we talked about that. Not only must it involve a kid under 12 who makes a statement about sexual abuse, upon himself, but once that happens, the court has to make a trustworthiness finding. They must find that the statement that was made to whomever outside the courtroom was trustworthy. And we talked about the kinds of things that we look at when we evaluate trustworthiness, right? We talked about it at least twice. Spontaneity, idiosyncratic language, those kinds of things. And the Idaho versus Wright Supreme Court of the United States case laid the groundwork for that. What Idaho versus Wright also said was, although video recording isn't required, we strongly encourage it. Because if you video record it, we can actually see the questions asked. We can look at what happened that day, and it makes life a lot easier. But they didn't mandate it. So back to Passaic County 3 years ago, when Giselle's notes became the record of the interview rather than the video recording, because the video recording didn't work. The Supreme Court of New Jersey eventually said it's not mandated, it's not required, and in fact, all 21 counties do it already anyway. So the upshot of that New Jersey case was that you don't have to video record, but just like Idaho versus Wright, they think it's a good idea, okay? And prosecutors and law enforcement, wink, wink, we think you should video record. Although we're not compelling you to, we think it's a great idea. And you never know, maybe in the future, we might make that a rule. It is a rule of court that all suspect interrogations, people who are in custody, who are being interviewed by law enforcement, have to read, if they want to question them and use those questions in the courtroom, they have to read the suspect their Miranda rights. And New Jersey has ruled, and it must be video recorded, unless there's a reason why you couldn't do it, which in the Giselle case, you know, the computer broke that day. Or sometimes you're out in the field and you don't have access to a recording device. You know, you're interrogating someone on the roadside in a vehicular homicide investigation, or some other such context where you could not video record, or video recording would be impractical. Nevertheless, it is a rule in New Jersey that all suspect interrogations have to be video recorded. It is not a rule, but strongly encouraged, that child interviews be video recorded. And, as a matter of policy, every county in New Jersey video records anyway, despite the fact that there's no rule requiring it. Now, Professor Myers, in your textbook, at page 172 and beyond, talks about the pros and cons of video recording children's forensic interviews. I want you to think about the reasons why that might be a good idea. Why does the Supreme Court of the United States and the Supreme Court of New Jersey think that that would be a good idea?
Prevent trauma from the child having to redo an interview over and over. If you videotaped it, you don't have to relive it thoroughly.
One advantage of video recording children is it may minimize the number of future interviews. Not eliminate them, but certainly minimize them. And the video recording can be used in a variety of ways. Number one, the prosecutor or the deputy attorney general who's preparing for trial, right? They have to prepare their witness. One day, if the case goes to trial, you have to bring the child in and prepare them for what's going to happen in the courtroom. So one way to understand that child and to understand what that child said in the past is to go look at the video recording and even go over that with the child, if that's your prosecutorial strategy, to prepare the child for what she is going to be asked or he's going to be asked. So the video recording will be real helpful. If the child is referred to mental health counseling, why do you think the video recording of the forensic interview might be helpful? Drafting off Susanna's response. Who might want to look at that? Therapists. The therapist might want to look at that and get a nice baseline for what to do next, right? Or how they're going to handle this child without having to go over all of that stuff again. Or maybe just going over certain parts of it that the therapist needs to clarify. But they certainly won't have to take a complete and total history from the child because they can look at the video recording. So it has the potential to minimize the number of times that the child is interviewed in the future. Professionals, mental health, medical, prosecution, different agencies. If I am preparing this case for prosecution, and let's say there's a similar proceeding before the family court, and the deputy attorney general, wants to go to a fact finding, and he wants to know what that child said in the past, or be prepared for trial. We can share the video recording, that is, criminal justice can share the video recording with child protection, and they can get a baseline of what that case is all about in preparation for family court. So yes, that's one advantage. What's another advantage to recording the forensic interview of the child? Why might that be a good thing, besides just sharing it with other professionals to minimize the potential number of interviews?
To see the reaction of the child.
We want to see the reaction of the child. That's good, that's correct. And why? Why is that helpful? To see the reaction of the child. What will we do with that knowledge now that we know how the child reacted? How might that assist child protection or law enforcement or anyone else?
I guess to see the context in which the child said certain things.
Well, you can see the context, but you can also read about it if someone took great notes or had a transcript of it for you.
Reaction, she might have a physical reaction to something.
A physical reaction meaning what? What do you mean by a physical? You're correct, but tell me more.
Like, I don't know, like, yeah, her body language might be.
Her body language. You can't get body language from a transcript, right? It's fascinating when you try cases in the courts. The court reporter, to this day, types down, although there are some video courtrooms now. The court reporter types down what's said in the courtroom. And sometimes jurors want what we call a readback. They have the case, they're deciding guilt or innocence, and they go, you know what? We want to hear the witness that talked about what happened in the alleyway. Can we hear that testimony again? And it's always interesting to listen to the court reporter read back what happened and then remember how the witness testified. And you certainly don't get the demeanor, their behavior, their body language simply by reading something aloud. So you certainly get to see and interpret the body language of the child, which may help us argue in what kind of case. We talked about the tender years exception to the hearsay rule. How might the forensic interview recording help us in the tender years assessment of trustworthiness? Body language, right? What else?
When it's an ambiguous situation, too.
Well, how does the video make it any better if it's an ambiguous situation?
Well, the child's response is going to let you know, like, if it's something that can go either way, the child's response or facial expressions, how they express themselves is going to tell you if it was something they felt was inappropriate, if it was serious, or if it was just...
Okay, so you're focusing on body language again. It's body language.
Their tone.
Their tone, that's a little different. Their tone, go ahead.
Like the spontaneous utterance, like you said.
Yeah.
If something just comes out, like as a reaction, you can use that.
Excellent, excellent. And that's a little different from body language. It's a little different from tone, both of which are important. Because the video allows you to see the body language. The video allows you to hear her tone, right? Okay? Those things are important too. And now we're focusing on spontaneity. The transcript doesn't demonstrate how quickly she answered, or whether there was a 5-second pause, right? So the manner in which she answered, the spontaneity in which she answered may be recorded. And you certainly have the potential to see that, where if you were simply reading, word for word, a verbatim transcript, one could argue that the video recording is superior to a verbatim transcript. Okay? Let's take a look at what Myers points out in the book.
Would it also be able to protect the interview committee if you obtain the interview or whatever? Because they're...
Excellent, excellent. One of the other things that we're on patrol for, that we're vigilant about, are leading questions, suggestive body language, suggestive tone, all the things that we just mentioned for the child, we can also observe from the interviewer, right? We can watch the interviewer's tone, we can interpret the interviewer's body language, we can size up whether they were using suggestive inflection or whether the question was presented in a suggestive or leading way, and you can do that a lot better with a video recording than you could simply with a verbatim transcript or even a summary of what was said. It preserves the child at that time too. One of the other things is you have an absolute record of how the child told at the time the child told. It freezes that child in time. By the time these cases come to court, certainly in the criminal system, but even in the family system, kids grow, they develop. And, you know, we size up people's credibility based upon how they present themselves and their appearance at times. That's how fact finders size up witnesses, among other things, right? Often, when the criminal system hears a case, the child may have gone from pre-puberty to adolescence. They may have gone from, an 11-year-old fifth grader to a 14-year-old who's now, chewing gum, tattooed, pierced, angry, rebellious, indifferent. But we get to watch the child as they were and how they expressed themselves when it happened. The jury's seeing that, that snotty 14-year-old on the witness stand is getting a very different picture of the person who told what happened back then. And it would be unfair, I think, to evaluate that child's believability based upon the 14-year-old child. It is an advantage to have a video recording of the 11-year-old child expressing themselves about what happened at the time or near the time that things happened. So that is very helpful when you video record things. It might discourage recantation, because if the child appreciates that this is recorded and this is documented for all time, it may discourage them from saying, I made it all up. And one of the advantages is that the video record, being an irrefutable record of what happened, might be used to help the child resist the pressure to take it all back, okay? You may also want to use the video recording to influence someone else who might be disbelieving. Who might that be? Who might you say, you want to take a look at this?
The mother.
The mother or the caregiver, the one who's going, this can't happen, I don't believe it, she's a liar, she's a troublemaker, I don't believe this one bit. You may want to show her, or him, whoever it is, parts of that video. Now, we normally don't share that video, at least right away, with the caregiver in law enforcement, but if it is advantageous to do that, if it is meaningful, if it has the potential to make that caregiver believe rather than disbelieve, you might want to share it with that caregiver, so that moving forward, that caregiver has a better picture of what their daughter or son said, and maybe being less likely to directly or indirectly pressure the child. Who else might you want to show it to try to get them to accept what happened in the case? Go ahead. The perpetrator, yeah, the accused. Great, absolutely. It may help facilitate a confession or an admission. I explained to you that we never judge or get aggressive or demean or talk badly to perpetrators. When we do a custodial interrogation of an accused perpetrator, we take a very gentle approach, a very understanding approach. We give them an opportunity to tell us their side of the story. We never get aggressive with them. It's not a good strategy, and the courts frown upon it because there's a fine line between being too aggressive, and that doesn't mean we're not assertive sometimes, but there's really little value in judging and being demeaning and being nasty and screaming and yelling the entire time. So we take a gentle approach when we can, and sometimes, despite all that, the guy says he didn't do it, and why is she making this up? I don't know why she's making this up. Well, you might want to take a look at a little snippet here. You think the jury's going to believe you or believe her? Is this the statement of someone who's making this thing up? And that may tap into, if they have any emotions, if you can tap into their emotions, and very often you can. A lot of these guys, they're just sick. They have some empathy. It's certainly not in play when they're molesting, but a lot of them, shortly after the molest, feel a tremendous sense of remorse, but they can't help themselves. The next time there's the opportunity, they do it again. But very often these guys, after they do it, can't sleep at night. They feel badly about what happened. They feel disgusted by themselves. And the video may help you tap into that emotion by showing them the little clip. They're going to believe you, or they're going to believe this adorable 8-year-old? You tell me. Now, do we do that all the time? No, but it's out there. The video recording may be a useful tool to encourage a confession. Trial prep, I mentioned, you might use it to refresh the child's recollection about things they may have forgotten. Because 2 or 3 years later, you're ready to go to trial, they may not remember everything. And you may say, well, remember you told us about the time in the truck? I just don't remember the time in the truck. Well, did Dad have a truck? Oh yeah, he had a red truck. It was a Nissan. He used to, go pick up the firewood up in Sussex County. Sometimes I went there with him. Okay, did something happen? I just don't remember. Show the child a video recording from a few years ago. And then watching their prior self describe what happened, that may tap into what kind of memory? What's the free recall or recognition memory? Close, that's good. Recognition memory. That video clip that you show the child about the time in the truck may tap into that child's recognition memory. Okay? If I just said to her, tell me everything about Daddy touching you, that would ask for free recall memory. But when you use a cue or a prompt or something that jogs their brain a little bit, we call that recognition memory. And you may be able to use the video recording as a tool to tap into the child's recognition memory and refresh it. Sometimes the defense, in light of that Margaret Kelly Michaels case, sometimes the defense in family court or criminal court may argue that the child's statement of abuse was coerced. It was forced upon them. And Susanna touched upon this before, looking at the video, we can size up leading questions or suggestive questions. Well, sometimes the defense lawyers will file a Michaels motion. Remember I told you that in State versus Michaels, the Supreme Court of New Jersey came up with a specific kind of hearing. And they used a word that means to sully, to dirty. Taint hearing. Thank you, a taint hearing. Now, let's say the defense says, listen, I don't think this child is testifying because she remembers what happened. I think, just like in Kelly Michaels, I think the Supreme Court's advisory that we have to make sure, by clear and convincing evidence, that this child's testifying from what they really experienced rather than from what the interviewer shoved down their throat. I think we got one of those cases, said the defense. They file a motion. And we're going to have our own experts say that there is good evidence that this child's memory was tainted. Now, the prosecution said, well, we're going to get our own expert. Fine. What's that going to do with the videotape? Come on. Who's going to review it? The experts, right? The expert for the defense can look at the video. The expert for the prosecution can look at the video. And they could testify, okay, about their opinion of whether the child's recollection was forced or tainted or corrupted in some way, or it's likely to be a true and accurate recollection. So the experts may use it, as well as the doctor and the mental health professional who's evaluating the child, experts who may testify in the prosecution, whether in the family or the criminal courts, may use it to understand what the child said and to look at a blow-by-blow actual recording of the interview and come to a judgment about whether that interviewer somehow coerced the child. Now, some people argue that video recordings are more trouble than they're worth, that there are many disadvantages of video recording. What might be a disadvantage of the video recording?
The child changed their story. When interviewed again, the video's going to hold more weight than what they say later.
Well, that would be an advantage.
Not
Right.
It depends on the side you're on.
Right. Well, we're looking at it from the prosecution side here. But that's good, though. We didn't mention that before. It might discourage recantation, but even if the child does recant, you can play the video for the jury, provided it gets in under Rule 803C27, the tender years exception. In fact, I know that recantation cases are easier to prosecute than cases where kids don't recant. It's a sad case because a poor child has to come into the courtroom and deny something that's true. I mean, I often say to jurors, especially when we try recantation cases, I mean, the only thing sadder than Dad creeping up the stairs at night and crawling into bed with Daniela is the fact that that's true, and Daniela had to come to court and say it's not. Yeah, please, thanks. So a recantation case is emotionally problematic on two levels. One is you have to have a child come in and relive this through the prosecution, and more importantly, that child has to lie just to save the family or herself, or for whatever reasons, has to come in and say something that is so is not. But nevertheless, what happens is that child comes into court, and as a prosecutor, there's nothing to ask them. You ask them about it and say, I made it all up. You ask a few questions about what motivated them to lie. And usually that motivation is disproportionate to the lie. Oh, Dad wouldn't let me ride my bike Friday night, or I wanted to go to movies with my friends and he wouldn't let me go, or, it's always totally disproportionate to the lie. There's a million lies little girls can make up to be mad at Dad besides saying he crawls in my bed and puts his fingers inside my body. I mean, that's the last thing in the world. And so that's a very powerful argument too. Jurors connect with that. You tell them that as well. But you just simply ask the child, what motivated you, and they tell whatever flimsy tale they want, and we thank them for their time. The defense doesn't ask them any questions, and they get off the stand. When the child tells the story, when a child testifies about being molested, that's the hardest thing because it's so difficult to get out. The child doesn't always understand the questions you're asking. The courtroom is very hostile and intimidating and scary and all that stuff. None of that happens when they recant. So in a way, it's bad, but it's good. It's good because then the video takes center stage. And you can't cross-examine the video. That's why it's hearsay. That's why it could violate the Sixth Amendment of the Constitution. But in this case, the child's available, so you don't have that Sixth Amendment issue. The child comes in and says, I made it all up, and we play the video for the jury. And the defense just looks at it. They can't yell at the kid on the video. They can't question her. It just gets played. I don't think we've ever lost a recantation case. Now, we pick and choose them. It's going to be a decent case if we're going to go to court with a kid who says it didn't happen. Nevertheless, we've never, I think we had a mistrial on one recantation case. But back to the negatives about video recordings. Remember, disclosure is a process, right? It's not a one-time event. You learn about that in forensic interviewing. And, I told you the best way to interview a child is for a single, highly trained interviewer across multiple sections. But child protection and law enforcement just don't have that luxury. It's one and done, most of the time. One and done. And you're never getting the whole story. Never. Even across 5 interviews by a highly trained professional in a clinical context. You're never getting the whole story. So what are you freezing here? You're just freezing, you're just documenting part of what happened to that child. And it exaggerates that part. Maybe they didn't tell Giselle about the time he would put his finger up her butt. And she only talked about the time that he would put his hand up her shirt. And that came out later and that wasn't recorded. Now, sometimes kids might leave that out because they forget it, and maybe sometimes kids leave that out because they don't want to think about it, because it's so disgusting, and if they think about it, it brings them back to the time Dad did that, and I can't think of anything in the world that's worse than that your father's putting his body parts into your anus. That's something that child may have just put out of her mind that day, or really didn't feel comfortable talking to Giselle about it. And then when they're in therapy, right, they're up at the children's house, okay, or they're at the Winona's house, Winona Littman Center, or they're at any one of these centers, and they're getting interviewed in their evaluation, or later in therapy, they make that disclosure. So what we've recorded is only part of what they experienced. And do you think the jury's going to place a bigger premium on what they said on the video, or pay more attention, or find that part more believable, or the part that they said to the therapist 6 months later during the interview? It's not going to have the same impact because it's not recorded, And so the jurors used to the fact finders used to seeing it recorded, it just feels different, right? It's not the same impact as having the video recording. And that's not fair, and it's not right. It's a fact. So that's a disadvantage of it. It really overrates and emphasizes that day to the exclusion of whatever else that kid may have said about her experience. None of which is any less important and any less criminal or any less an act of abuse or neglect than what she said on the video. Except that it wasn't recorded and it's just viewed differently. It just is, by all of us. Because it ain't on tape. So that's a disadvantage, one would argue. The video recording exaggerates the statement that the child made that day. Okay? As Professor Myers says at page 176, 177, the United States Supreme Court observed in Idaho versus Wright, I mentioned that earlier, right? That out-of-court statements made by children, about sexual abuse arise in a wide variety of circumstances. Opponents of videotaping emphasize that it is not possible to videotape every contact with children, but if it becomes the norm, children's statements that are not on tape may be viewed with unwarranted skepticism. The ones that aren't on tape. I just said that. That's what I've been saying. So Myers points that out too. Okay? What else happens to people? You know, you go in the video room and you're asked to go interview a child who may have been molested. There are so many blocks and obstacles to that child telling you what happened. You're asking her to make a statement against someone she loves and trusts, someone she lives with, right? You're asking her questions that are typically beyond her understanding, certainly beyond her sexual understanding. I mean, it is very difficult. There are dozens or more blocks to getting information from children when you go into the room. And now the video recording may add another block. What block might that be that I'm referring to? When we let the child know that they're being video recorded.
They might be intimidated.
Thank you. They might be intimidated. Do people act differently when there's a video camera? Sure they do.
Look at all the
Look at all these judges and court proceedings that are video recorded, how people act way differently, at least it seems that way, when they know that there's media or cameras in a courtroom. It could cause stage fright for the child, okay? We worry about that. That's a potential disadvantage. And we tell the children they're being recorded. We don't do it covertly. I mean, we don't bring the child from one supreme act of betrayal and impose another act of betrayal on them by lying about what's happening. Okay, so we tell them up front they're being video recorded. It could fall into the wrong hands. The defense lawyers can exaggerate one section over the other. Okay, some of you may remember when the police beat a man named Rodney King in the 1990s, and the defense lawyers kept playing over and over again one little snippet of one little arm movement or whatever. And, you know, the defense lawyers over-exaggerated something that he did either before or during or at some aspect of the beating. And the police wound up being acquitted. And some professionals have argued that had to do with the fact that, in part, that the defense was able to exaggerate some of the things that Mr. King did when he was being assaulted in the ground. Because they had the video, and they look at that, they're playing it over and over again. And it's like, oh, it took on more of an importance than it really would have had at the scene. So the video can manipulate, it might not be the right word, but exaggerate it with that rewind button. Of course, things can be taken out of context. You know, an interviewer makes 2 or 3 mistakes. They ask a couple of leading questions, and they ask a suggestive question. It happens to everybody. But now the defense can exaggerate that as well, right? Let me rewind that in case you missed it. Look what Giselle does there. Let me rewind it again. On summation, let me show you that part. Now, one single question out of 198 questions, you know, takes center stage, and it's played over and over again, and through exaggeration by the defense, it becomes more important than it really is. Some argue. One of the disadvantages, right? Now, I believe, and most professionals believe, the advantages far outweigh the disadvantages. And their responses, for example, the stage fright, kids just don't act much. You know, it's we adults who get a little hinky when video cameras are on. In my experience, over many, many years, you know, they may look at it and we tell them, listen, it's not the kind of video that's going to be on YouTube or, you know, on TV or anything like that. It's just something so that I remember what we talked about today, and so that other people that need to know can remember what we talked about today. Okay? Now let's move on. Okay, and they talk. You know, it's not a big deal. It really isn't. It feels like it will be a big deal. It has the potential to be a big deal to some witnesses and some kids, but it's just not. These worries never really manifested themselves, at least that worry. Okay? Certainly the defense lawyers can mess around with it. It could fall in the wrong hands. You know, if it's not recorded, you know, then they can argue that it's somehow not as important, or at least the inference can be made, and that it's less credible because it wasn't recorded. I mean, these things happen, and you got to deal with them. You know, in the Giselle case that went to the Supreme Court, the thing broke. The machine broke. The recording machine broke. It didn't record everything. All of a sudden, it's like the end of the world. What do you mean? Throw the case out. Let the molester go free. You should have been recorded. You know, and I remember talking to the Attorney General who was arguing it before the Supreme Court, and I said, listen, this is what I would open to the Supreme Court if I was handling it. I would just look them in the eye and go, Justices of the Supreme Court, technology fails. Things break. They don't always work the way they're supposed to. We all know that in our lives. You know, sometimes you set the DVR to record your favorite program, you come home and see it record. Does that mean it didn't happen? No. Does that mean we ought to throw out the conviction of this man because it broke? What were we supposed to do? I think what we did was what reasonable people would do. Immediately after that, we took copious notes and we wrote a narrative to the best of our memory. Now, we had the option to interview the child again, but we chose not to do that. This child had just been through an hour-and-a-half interview about being molested by her father, and we practiced the child first doctrine. And we focused on the mental health of that child, and we decided that the notes were good enough in this case. And fortunately it won the day. But so there are advantages and disadvantages to video recording. You should know them and become familiar with them. And they're in Professor Meyer's book at pages, I think what did I say? Yeah, 176, 177, around there. Any questions about that? All right. Now, just to revisit something, I know Susanna commented right at the time of the Boston Marathon bombing, a few observations about Miranda and the Constitution and the surviving bomber, okay? Susanna posted in Cyber Cafe. Yeah, something's buzzing. Is that someone's phone? Oh, that's you? Okay, I don't mind it. The buzzing, I don't mind. I just want to make sure it's not me. Susanna says it annoyed me, and you know, the press was all over that, and how come you didn't read him his rights, and nobody's questioning him. The guy just came out of a boat that got pierced with like 100 bullets, and you know, he's got a bullet in his throat. Nobody's going to be questioning him at that point, okay? And unless you're going to question somebody in custody, I don't think anybody would argue that he wasn't in custody, right?
Well, that was kind of my question. Who was they, like, why would that not be a simple explanation? It carried on for too long on the interviews on TV with like the federal prosecutor and stuff, giving all these long rationales as to the whole Miranda thing, and I'm like, why doesn't she just say what you told her, you know, very simply, and get it off the
Well, there were two things there. I think with that, I didn't see the U.S. Attorney explain why they didn't do the Miranda, but it wasn't about, from what you said, it wasn't about the fact that they weren't questioning him at that point. They want to question him, they intended on questioning him, but nobody was going to question him at that point. So a simple answer is, we weren't questioning him then.
Right.
We let people know their constitutional rights prior to questioning. And in fact, if you had read him his rights in the boat, let's say, I don't know if you know, he was caught in this boat in someone's backyard.
He was like incoherent.
Right, but even if you gave him his rights in the boat, they dissolved, and then you interview him 3 days later, you got to do it again. There's no point in reading him. There was absolutely no point in reading him his rights or telling him his rights in the boat. What the prosecutor was talking about was something different, though. There's a public safety exception in the federal courts, not in New Jersey courts. If there is the potential for people to get killed, serious bodily harm, terrible things to happen, you can question a custodial suspect to prevent tragedy, let's put it that way. So there is a public safety exception. But that's usually when something's imminent. You know, not if like we want to make sure that there's nothing happening in Russia or something in the past. I mean, there's got to be other bombs. And in this case, you could argue that pretty well. You don't know how many bombs these guys hid, right? You may need to talk to him under this federal exception about where he hid other bombs. I mean, these guys are throwing, what do you call those food things that they make?
Pressure cooker.
Guys are throwing pressure cookers out of the vehicle, for Pete's sake. I mean, they not only put pressure cookers at the scene, they have at least one pressure cooker on their person. Others were pipe bombs. Anyway, who knows? So the other argument is, we didn't have to read him his rights.
That's what she kept going on like the long, it took her like 10 minutes to explain that. That's why I was like, why are they wasting time? Why doesn't she just get to the point and tell people, we don't have to?
Yeah.
That was her excuse.
But to explain it to you guys a little bit more, there's a public safety exception, and it simply means that if you legitimately and reasonably feel that by reading him his rights, people are going to die, or bombs will go off, or some terrible calamity will happen, you don't have to read him their rights. Now, the last thing is, if you don't read him his rights and he makes statements, you simply don't get to use that in court. These guys are convicted. There's video of him walking down, putting the bag down, right? He's running away. There's no doubt about guilt. We don't need his statements. Now, they may want his statements for whatever reason. They certainly want his statements to prevent future tragedies like this, to have better intelligence gathering in the future. There's a lot we can learn from him. But that has nothing to do with the Miranda. The Miranda is about whether we're going to use what he says to prosecute him. You don't need what he says to prosecute him. You don't care about his Miranda rights. You want to talk to this guy, and he ain't reading him any rights. Because we're not going to go to court with those words. Those words are going in our brain, and we're going to go save people, or we're going to prevent future tragedies. That's why we want those words.
If you have somebody, somebody got interrogated by the detainee and didn't read him Miranda, and then so obviously that you couldn't use, and then they were interviewed again and the same questions were asked by someone that did read him Miranda, does it matter when they're asked, or once the question's asked, it's like screwed?
It matters. I don't want to get into that, but it matters. There's different rules in different systems. The federal system has one rule. State system has another rule. In a homicide case I'm trying right now, the death of a 21-month-old, the suspect had the baby all day. The baby had catastrophic anal and vaginal injury and brain injury. And when he came to the Passaic police, they didn't read him his rights. And then the baby died. And then he came to my office, and my team read him his rights. So kind of those issues came up. They didn't read him his rights, but then we did. So can we use what they said, what he said to them? Can we use what he said to us? And interestingly, if he confessed to them, and then he came to us and then confessed, it's possible we couldn't use, and we gave him the Mirandas, we couldn't use what he said anyway because of the cat in the bag doctrine. And that's just a metaphor for he already admitted it there, so he had nothing to lose by admitting it to us. So his rights were undermined with us, even though we gave him his rights because of the prior unmirandized confession. But again, that's very sophisticated stuff. I don't want to really get into that too much. Go ahead.
Is there ever a time when a suspect says that the police didn't read them their rights, and then the police say they did?
Oh, all the time.
That's the first thing out of their mouth.
Every Tuesday afternoon down at the courthouse, say Patterson, Middlesex, Essex, Sussex, all over the state. They say they did, they say they didn't. However, now, it doesn't happen so much. I shouldn't have said it so flippantly because we have to video record. So now we know they get their rights. They're on video. But when they're on the scene or they're in the field, you still don't have the cameras rolling, so those issues can arise, even in 2013. But those arguments used to be all the time, as I just said, but not so much anymore with the video recording. But yeah, no, and it's great. You know, I argued from the early 2000s we should be recording suspects. Same reason why I argued in the 90s we should be recording kids, and we do record kids. Because what the defense lawyers argue is BS. It doesn't happen that way. We read people their rights. We don't beat them during interrogations. Beatings don't work, you know? But because it's not recording, the defense can raise the specter of evil in every case. And somebody going, geez, it could have happened. I don't know. It seemed pretty persuasive. The cops, I don't believe the cops. I don't believe the guy. I believe a little bit of the cops. A little guy. We don't have to worry about anything. It's all on tape. Don't worry about anything. And the defense were very good at raising the specter of all kinds of nastiness and evil that went on in the room, you know, or in the interrogation, which was so far from the truth and so against law enforcement's interests. That's what the jurors really didn't get. That's not even a good thing to do, man, you know. So anyway, it's all recorded now, and that's a good thing. Now, let's get back to confidentiality, where we ended last week, and examine some of the issues surrounding confidentiality and children and justice, okay? Now, one of the cases that you had to read, by the way, when we left, we talked about 3 sources of confidentiality. Someone tell me, what are the 3 general sources of confidentiality in the law? Why is it confidential? Because it fell out of the sky? What makes stuff confidential? Go ahead, you tell me.
Ethical duty to respect.
An ethical duty. There may be an ethical duty. And ethical duties arise from where? From the statutes? From practice and rules and regulations that govern professionals in their professional associations and relationships. The American Nurses Association, the American Medical Association, the NASW. Someone tell me what NASW stands for? Thank you. National Association of Social Workers. Ethical. What's the second source of confidentiality in the law? Statutes. What's an easy one that comes to mind? Who has a big old statute that makes stuff confidential? Well, HIPAA's a statute. Very good. HIPAA's probably the most well-known statute that bestows confidentiality upon health records on the planet. HIPAA. Very good. What's another one that's more Jersey? Title IX, which governs what records? Whose records? DIFAS, DCP&P, DIFAS. Very good. And the last thing has to do with what kind of proceedings? Legal proceedings. Legal proceedings. And what do we call those very special kinds of confidential things? Privileges. Privileges to do what or not do what? A privilege not to do what? Not to testify. Thank you. And that's important. The word testify, not sharing information, testify. It's all about testifying in a legal proceeding, whether it be a deposition, whether it be a family court action, whether it be a civil prosecution, right? You don't even have to be in a courtroom. Depositions are usually taken in offices where lawyers will bring parties to litigation in and ask them questions under oath. Privileges apply there because it's testimony. That's considered testimony. So those are the 3 sources of privileges. 3 sources of confidentiality. The last one known as, more formally, as evidentiary privileges. Testimony is a form of evidence. Some people are privileged, okay, under the federal rules of evidence to not have to testify. News persons, rabbis, spouses, there's a bunch of them. We talked about some of the more common ones, especially the kind that arise in the context of children and justice. Okay? Now, even though spouses are privileged, a wife does not have to testify against her husband. What about in child sexual abuse prosecutions or child physical abuse cases? Can a wife or spouse rely upon the testimonial privilege known as spousal privilege? No. Privilege is not available in child abuse for spouses. Now, news person privilege is something else. But we're not going to let the parent get away with relying on privilege to say, to protect the other batterer or the other abuser or neglector, if you will. Domestic violence, too, we talked about. That ain't going to fly either. Well, you can't testify against me. That's so preposterous, it's not even worth talking about, right? But you still want to think about it for a minute, right? Spousal privilege. What about, and guess what? In a significant majority of domestic violence or intimate partner violence, we call it now, the intimate partner who was battered comes in and doesn't want to go forward. And if it was allowable, I could see them go, I'm relying on spousal privilege. Right? I want to rely on that. This way you can't make me be a witness against my boyfriend. But it's unavailable, so not available in those kinds of cases. Now, sometimes you get something called a subpoena when you're a professional. A subpoena is just a document which compels you to come to court. okay? But you do not have to follow it if there is a privilege or if the records are confidential. You have to respond and say, I'm not following this subpoena because it asks for confidential records or privileged information. But lots of professionals just simply react and start babbling or handing out records. Oh, there's a subpoena. There's a subpoena. And subpoenas can seem very lofty and powerful and majestic. Be it here known that ye shall come to the courthouse under the command of the king. Well, they don't say king anymore. But under the command of the governor and you go, oh my God, you better, and he shall be arrested and taken into custody forthwith if you don't comply. It's just easier to go, what do you need, dude? Go ahead.
Our DAGs love to subpoena, and when they send out a request for a subpoena, we usually get the information. So sometimes it takes long for us to get information, but once our DAG is on it, we usually get it back quick.
Well, look. Sometimes subpoenas are appropriate, and you got to get the information over. And the DAG or my staff, let's get the stuff. We're not going to win here. You got to turn it over. There's an exception to privilege. But I'm most concerned, and I'm trying to teach you that simply because you get a subpoena, you still have to evaluate its confidentiality. And as a child protection worker, and this is standard procedure. But if you work in a doctor's office, everybody's here is a DCPP person. You work in a doctor's office, or you were a teacher, or health. Education records are governed by Title 18 of the United States Code. You just can't give out kids' education records. So if you're a teacher or you're a child protection worker or whomever, and you get a subpoena, don't be shaken by this rather fancy document. You get a seal on it. You don't do this anymore. But you used to go down to a stationery store. They'd sell you a book of subpoenas to a lawyer. Now lawyers are allowed to issue subpoenas. They're allowed. But subpoenas don't override confidentiality in and of themselves, okay? The information they're requesting and the context in which it's requested could override confidentiality. If the subpoena came from the prosecution in a child abuse case, well, that's going to override confidentiality. Now, DICUS is a statute that says DICUS has to give all their stuff to the prosecutor, so there's a statutory exception to confidentiality. And in New Jersey, confidentiality of DICUS records are statutory. So Title IX has what you can't give out DICUS records and about 20 exceptions. And that's okay. But there are certain times where the subpoena will be effectuated, and then you have to turn the records over. Just like in the courtroom, the judge may override confidentiality. Confidentiality is not absolute, ever. It can always be pierced. Some things are easier to pierce than others. Okay? It's confidential whether you wear eyeglasses to drive. There's some law that makes that confidential. Well, among the things in the world that are confidential, that's not at top of the pops, That one can be overridden rather easily. Nevertheless, there's a rule governing confidentiality of some things that are more important than other things. So, a subpoena, here's what you need to do if you're a professional. You're a nurse, you work in a doctor's office, you run a daycare center. You need to talk to your attorney or to some supervisor who knows what they're doing. Okay? Child protection needs to talk to a DAG. An education professional needs to talk to the attorney that represents the school district. Now, many school districts have an absolute rule. No. That's their rule. No. Don't give anything out. No. And many institutions, all subpoenas have to go to the lawyer for the district. And in many hospitals, it goes to, I don't understand why this is the name of this place. When I subpoena stuff from some hospitals, you have to send that to risk management. Risk management. The prosecutor for the county, this person's been raped and assaulted. I got to go to risk management. I think you got to go to Guadalcanal with Bona, or you got to go to the attorney for the hospital. I got to go to risk. Who in risk management is going to evaluate the propriety? Who is this person? Risk management has lawyers that work there. I'm being a wise guy here, but it just doesn't sound like the right place for the subpoena to me, risk management. But so many entities have a process and a rule, but sometimes small community-based programs, they don't know. They just give out the stuff. There's a case, I don't know if it was among your cases to read, State versus JG, I may have taken it off, where the victim counselor privilege This one here, victim counselor privilege, was an issue. And the persons at a small community-based mental health place, they just gave a whole bunch of records to the defense lawyer because he asked for them by subpoena. And like I said, don't be intimidated by a subpoena. Always check with somebody. Lawyers, they're not evaluating it for whether it asks for confidential records. They're not your lawyer. They're just issuing a subpoena. The other thing you should be mindful for, and this works in nearly every privilege. There's a couple of kooky ones. I don't know how it doesn't work, but I guess when there's dual privilege holders. Somebody always has to be the holder of the privilege, right? Attorney-client privilege. The attorney doesn't care about private, it's not his private information or hers. It's the client's. So in attorney-client privilege, the client, the accused, is the holder of the privilege. Right? And doctor-patient privilege. The doctor doesn't care if the world knows that, she has multiple partners. It's the person who cares about their private life, right? He's not the holder of the privilege. The patient's the holder of the privilege, right? So what can the patient do to get the damn records? Fill out a waiver. If you are the privilege holder, the patient, the client, you can waive the privilege. So sometimes I'll have a case where a child, let's say a child was sexually molested in the hallway of Clifton High School, and there's an investigation and prosecution is imminent. I'll ask the school for the records of the kid because they're relevant to the case. Oh, you can't give me those. You can't give me. No, they're privileged. They're confidential. Privilege is the wrong word. Privilege is for courts. They're confidential. We can't give you the records. Okay. The records belong to Danielle Pasillo. They're her records. I'm going to fax you a waiver. She's here with her mom now, and because she's 11, her mom will sign it too. Well, fax it. No, can't do it. Dude, it's a waiver. Mom and child are waiving the privilege. The privilege is there to protect them, and they don't want the protection. I'm going to fax you the waiver. Can't do it. I'm going to talk to my supervisor. Okay, so, no, can't do it. I want the supervisor. Here's what the supervisor says. Check this out. Wait. We're not going to accept the waiver. But if you send fill in the blank, subpoena, we'll give you the records. Oh, don't you want a subpoena? Go get the book of subpoenas, will you? Put some red wax on it, a bow. They want the subpoena, and I just got done telling you, subpoena is a piece of junk in the legal system. It's not a piece of junk. It's an important document, but it is very low on the thing that can cause privilege to fall by the wayside, or confidentiality to fall by the wayside. So it's funny, I'm giving them a waiver. No, I talked to my boss. He wants a subpoena. You want a subpoena? All right, here, that's easier. Subpoena. Now the rights of the victim are irrelevant. Del Russo's a lawyer in this state. He issued you a subpoena. So, but a waiver can abrogate privilege, okay? If the privilege holder signs the waiver, it's got to be the privilege holder, right? Not even the mom. It's got to be the kid and the mom if they're younger. So you can have a waiver, and there are other things that abrogate or that override confidentiality. One of the most important ones for our purposes is front and center in the Snell case. And that is something we studied earlier in the year. What did we study earlier in the year? That's a statute in New Jersey that applies in child abuse cases. A statute that requires teachers and cops and doctors to do something. Mandated reporting. Mandated reporting overrides confidentiality. Always. Always. No matter what. Priest, patent, news person's privilege, the fanciest privilege, the fanciest confidential. HIPAA. Oh, HIPAA this, HIPAA that. Mandatory reporting overrides confidentiality.
Could you be a mandated reporter and want to remain anonymous?
Hold that thought for a minute. New Jersey, everyone's a mandated reporter. Other states might be profession, we talked about that, but every person's a mandated reporter. Yes, and the answer to your question was, can you make a report anonymously? Yes, and you follow the mandated reporter statute and you're anonymous. What burdens me are the teachers who want to remain anonymous. Okay? You know, it's a busy doctor's office. We want to remain anonymous. You're a doctor, man. You took the oath. I mean, you're gonna. I mean, of all the people, that's really for people who are like living in an apartment. They're afraid. They're afraid of repercussions or gangs or whatever. You're a doctor, but even a doctor can call in anonymously. Even a prosecutor. Go ahead.
I have a question.
Yes.
The referral that we received, I was told that it
The
cannot.
what received? I'm sorry.
The referral, when we get the referral.
Oh, the referral? Okay.
Yes. I was told that it cannot be used in court because it's considered as hearsay.
Well, the referral may or may not be, referral is just a word we put on it. It's just somebody else told you something, we wrote it down. So it's just a summary of what someone told you, right? Isn't a referral a summary of what someone told you? It's no different than any other summary of what someone told you. Referral, 9-7, whatever you want to call it, the NJ Spirit, field notes. It's just a document of what someone told you. And what's in there is hearsay. Same as hearsay is a police report, a hospital record, it's hearsay. However, hearsay, there's a bunch of exceptions we talked about in this class, right? There's exceptions for medical diagnosis exception, there's children under 12 exception, there's a bunch of them. And in many of the early DIFUS proceedings, the hearsay rules are relaxed, they don't apply. In that initial hearing on the order to show cause, when you have an emergent hearing, or the DOD, right? What's that first hearing called that you have? The initial appearance, first appearance? Order to show cause, right? Okay, the order to show cause, hearsay is allowable there. They allow all kind of hearsay. The DIFUS record is full. It's just a bag of hearsay. It's a big stack of hearsay. It's admissible most of the time. Now, what's in there may or may not be admissible depending upon how the court reviews it. The referral, it's admissible at the order to show cause hearing. It's not so much the referral, it's what somebody reading the referral saying what someone called in. That's going to be admissible at the initial order to show cause hearing. It may not be admissible down the road. And again, it all depends upon who said it, how it was said. What if the referral was this? Oh my God, my husband's burning my son with a lighter. That's an excited utterance, right? Who cares if it's in a referral? It may be admissible as an excited utterance. We're talking about excited people making excited statements. So don't get, that might be a shorthand way of letting you know what's in a referral never comes in a TPR, like the guardianship, termination of parental rights. No hearsay. They don't allow hearsay. So the referral probably ain't coming in a TPR, where it may come in the order to show cause, and depends upon. Anything the child says, 0 to 18, in DIFUS proceedings, admissible. There's a statute. Not in my cases, as a prosecutor, but in child protection proceedings, whatever the child uttered from 0 to 18 is admissible without regard to hearsay. So the referral might say, neighbors say she spoke to child said, well, that's in the referral, but DIFUS has a special statute that lets that in at any point in the proceedings. But that's something we got to think about, though. You're good in making that observation. Mandatory reporting trumps all confidentiality, even the famous HIPAA. If you read HIPAA there, number 4, you'll need everything you need to know about HIPAA. It's right in here for you. Nice summary. It's actually called the Health Insurance and Health Insurance Portability and Accountability Act. That's what it stands for. Number of exception. First one, required by law and mandatory reporting laws. Okay? A covered entity may disclose protected health information to law enforcement if it is required to do so by law. And it is in New Jersey. So all the exceptions and all the HIPAA stuff is in that particular article I gave you. And as a general proposition, mandatory reporting trumps everything. Now let's take a look at what happened to Snell. Snell was a psychologist. His name was Dr. Philip Torrance. And this paragraph here kind of summarizes it. Although Dr. Torrance is a physician, he sought to avoid the physician-patient privilege by relying upon the psychologist privilege. What happened was, and you correct me if I'm wrong, you read this more recently than me. He was a grandpa, and he performed sex acts on his 2 granddaughters, and he confided in grandma. his wife, and she said, oh, you're a creep and whatever, we're going to send you to a psychologist, a doctor, you're not, what you do? So he gets sent to a psychologist, right? He confesses to grandma that he molested his grandkids. Grandma flips out and makes him go to the doctor. The doctor is evaluating him for intake, like, all right, why are you here today? Do you have insurance, and why are you here today? And he says, I molested my grandkids. So he got to report it to DIFUS, and when he reported it to DIFUS, the prosecutor tried to subpoena him to come and testify or make a statement about what the patient said to him to use in the criminal prosecution. Okay? So if you look at it, he's relying upon psychologist-patient privilege and I'll give you the upshot of it. The prosecutor and the deputy attorney general said, listen, there's mandatory reporting. He's required to report this. He did. And there's mandatory reporting and sharing of information between DIFUS and the prosecutor. So he told DIFUS, DIFUS told us, the cat's out of the bag, we should be able to use it in the criminal prosecution. The appellate division said, and this is good law until this day, here's the rule of this case, Dr. Torrance was required to report this to DIFUS. No ifs, ands, or buts. Okay? He did. That is unambiguous. He has to do that, and he did it. On the other hand, the prosecutor cannot force him to be a witness against his own patient in the criminal case. So he has an obligation to report it to the civil authorities, namely DIFUS, but no obligation to report it to the prosecutor, and the prosecutor cannot compel him to be a witness against his own client or patient in a criminal case. And they go through all of the reasons why and the public policy behind that. Why can't I go left to right here? You know what we have to do here? Snell. Save linked file as Snell. Save it. And I'll put it in downloads. Snell. At least they know I'm going up and down. The facts are not in dispute. Defendant, a 59-year-old man, was engaged in a long-term relationship with a woman. Okay, they weren't married. He referred to as his paramour. She had two granddaughters, 11-year-old KM and 10-year-old SM, who were sisters. Safety concerns had led DIFUS to remove SM from her mother's home and place her with the grandma. What luck, huh? KM lived in nearby Trenton and would occasionally visit. The children regarded the defendant as a substitute grandpa. It appears that over a period of more than a year, defendant repeatedly performed cunnilingus on them. On at least one occasion, SM was present and witnessed the act. Defendant claimed it was It was his intent to educate and instruct the minors. I've heard this defense so many times, and still shockingly goofy. That it was intent to instruct or educate the minors so they wouldn't be sexually involved with boys. For some reason not apparent in a record, he told his paramour, he told grandma what had taken place. Now, grandma sends him to Dr. Torrance. During the consult, defendant admits to the doctor that he performed cunnilingus on the girls. He felt it incumbent upon himself to call DIFUS, and he did. Okay, and then they cite the mandatory reporting statute. So that part was rather clear. Part 3 here. While we agree with the state's conclusion that the doctor had a duty to report, we are unable to accept the state's entire reasoning because we find that the defendant's consultation with Dr. Torrance was akin to a client seeking an attorney's aid, and the commission was not akin Yeah, the prosecutor said this is like, if you're a lawyer and you represent a client who's going to commit a future crime or part of an ongoing fraud, then you have to report that. You have to report against your client, even an attorney. Now, if he murdered 50 people in the past, you certainly have no obligation to tell the justice system that he murdered people in the past. But if he says that I'm going to murder someone tomorrow, or I'm part of a fraud scheme to defraud Medicaid, an ongoing crime, you have to report against your own client where it's an ongoing crime or a crime going to happen in the future. The prosecutor in Snell said this is similar to that. This is similar to the attorney-client exception where the attorney has to inform on his own client because they're going to commit a future crime or they're in the middle of a crime right now. The Supreme Court said, listen, or the appellate division said, we can't agree with the Attorney General that this was similar to that situation. Defendant consulted Dr. Torrance to seek treatment so he might refrain from committing further acts of child abuse, not to seek aid in the commission of future acts. In other words, he didn't go there to, like, I need to know how I can do this better, or I want to molest more kids, I just want to know how to get away with this in the future. He went there ostensibly, the court says, to get help so he doesn't do this again. So this isn't like an attorney and a client who's going to commit future crimes. And it says, that under the factual scenario, the state cannot argue that. And they finally said, we conclude, right here at number 6, that Dr. Torrance's report to DYFS was proper, but he may not be compelled by the state to testify as to the content of privileged communications at the defendant's criminal trial. Operative word there, criminal trial. What he told DYFS, he's got to stand by. Even when he goes to family court in a fact-finding or an order to show cause or a fact-finding or a TPR or anything in the family court, he's got to stand by his disclosure. But in the criminal courts, the prosecutor can't use it. They got to convict him by other evidence. So who am I going to subpoena now? Okay, I don't get Dr. Torrance. Who are we going to subpoena? Detectives? Intake workers? Come on, man.
In a criminal case?
In the criminal case.
Grandma.
You can't get him. Grandma.
No, I thought you can't do it if she's married. No, she's
No,
not
no.
married.
It's Paramore.
Not Paramore.
Should have got the paper.
Grandma.
He not only admitted it to Dr. Torrance, but he admitted it to Grandma. And that's very good, though. Immediately, she's like, spousal privilege.
Yeah, I thought she
And I'm with you.
was
But wait a minute,
married.
no spousal
Married.
privilege. They weren't married. So she would be compelled to testify. Now,
What if they were to marry, like, I don't know, the day after or something?
They
Because
can.
he knew that.
no, many people have tried that. Well, you know what? Actually,
before?
I think it was though, but they weren't married at the time.
Right.
yeah, I
Yeah,
know.
before,
People
right?
have tried that. I'm not so sure.
What
You know, I think that might be a problem now that you mention it.
What about a common law?
But that would be totally a scam. I mean,
No, of course.
But it doesn't matter, people have done it, right?
People do.
I don't know. We have to look. Get on that one too, Suzanne.
Can you tell somebody else?
No, I'm kidding. Nobody's doing this. I'm not so sure about that. I'm not so sure about that. But how about this? I don't know how long they were together, but things are moving throughout America to have same-sex marriages, right? Now, if you don't recognize marriage, which many states, most states, don't do that, and it's before the Supreme Court, and they're probably going to issue an opinion soon, and it's not going to be the opinion sanctifying gay marriage. That's not going to happen, just from the kinds of questions that were asked. But that's the road that we're going on legally in America. But some states recognize legal partnerships, right? What do they call them? Domestic. New Jersey recognizes domestic partnerships. Other states may recognize these kind of civil unions that are marriage-like when it comes to benefits and health and whatever else, inheritances, right? All that. What about spousal privilege?
I was wondering, is that a problem?
What if they were together for 50 years? I don't think it's going to apply. I don't think it's going to apply. But this is what makes the law interesting if you're interested in the law. Times change. right? Words are ambiguous. Things need interpretation. I think right now grandma would have to testify. If they marry tomorrow, I don't know, gotta look it up, figure it out, see what they've done in other cases, similar cases. See how the New Jersey courts have ruled in the past on similar cases with similar issues, right? What if there were domestic partners under domestic partnership law? I don't know. That's why there's lawyers. Figure it out. Go to law school. You know, that's what attracted me to the law, these kinds of issues, these ambiguities, the research that comes with it, and making an argument. So anyway, for our purposes, mandated reporting overrules all confidentiality. And specifically, in New Jersey's mandated reporting statute, you have to tell DIFUS, even if you're a fancy psychiatrist, but you cannot be compelled to be a witness in the criminal case. That's what Snell says. That's State versus Snell.
That's why so many times you're split, like one court will find one and the other court will find the other.
Sometimes that happens, yeah, and that's why you have Supreme Courts. They try to resolve the conflicts among the smaller courts. Okay, so that's Snell, and here's another famous case. Okay, now this is a summary that I did of it. This is the case of Tarasoff versus the Board of Regents of the University of California. Okay, now the murderer in this case was named Prasenjit Podar. He was a Bengali, and he had worked his way through the Indian educational systems, and he came to California to study naval architecture. He studied belly buttons? Is that the way you spell naval? That's wrong. I think it's A-L. Naval architecture at the University of Cal Berkeley in '67. Then he meets the beautifully named Tatiana. He meets Tatiana Tarasoff, and despite his attempts to romance Tatiana, she was uninterested and rebuffed his advances. After Tatiana's final rejection, Prasenjit began to exhibit symptoms of clinical depression, eating and sleeping irregularity, didn't go to his classes or his job, and listened endlessly to tape recordings that he had secretly made of his conversations with Tatiana. Upon urging of a friend, he went to the hospital. Nice. He confided to the clinical psychologist he was seeing at the hospital that he was going to kill Tatiana. After consulting with 2 psychiatrists, the psychologist decided to commit Prasenjit for observation and report the threat to the campus police. Now, so far it looks like the university, now these psychologists, they worked for, the reason California got sued was because they run the University of California at Berkeley, UCLA. UCLA is University of California at Los Angeles. This was the University of California at Berkeley, also known as California or Cal Berkeley. They sue California and Cal Berkeley, which are governmental entities. Okay? And they sue them because they also got what we call deep pockets. Okay? The psychologist, he ain't got a lot of money. The psychologist maybe makes 100 grand back then. He's lucky. 80 grand. But California University got a lot of money. So they sue them. So far, it looks like California and the psychologist did a good job. Would you agree? Yeah. Well, let's see what happens. He gets this. What does he do? He has him committed. You know, it says here, right here, up to this point I'm saying. So what does he do? He talks to 2 supervisors. He commits Prasenjit for observation. Commit means he forcibly takes him off the streets for mental health reasons, okay, and institutionalizes him. And he reports the threat to the campus police. So far, so good. Although the police briefly detained Prasenjit and they searched his apartment, he was eventually released because he appeared to be rational and stated he'd stay away from Tatiana. So now things are going in a bad direction. He never went back to therapy, and his supervisor said there's nothing else you can do. And the reason was that he's stable now, he's okay, and he has a right of confidentiality. And they said no further action. And on October 27th, 1969, Prasenjit Podar killed Tatiana Tarasoff. After Tatiana's death, her parents sued the university. The lower courts dismissed the civil action because there was no cause of action because the university owed no duty of care to Tatiana as she was not their patient, she was just a third party. Now, the California Supreme Court reversed the lower courts and allowed Tatiana's parents to maintain their cause of action against the university for failure to warn. Now, that's a procedural thing. That really had nothing to do with the failure to warn issue. They argued, listen, you got the wrong person here. California didn't do anything wrong. If anybody did anything wrong, it wasn't us. The court said, no, 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 you could be sued for this. And then when it went back to the courts, it announced the rule about duty to warn third parties, okay? So the court considered, and the holding and the reasoning are disjointed. I got to fix this. But the issue was, now that they're a proper defendant, did they have a duty to warn? And the court said they considered the impact of the confidential nature of mental health communications and the necessity of obtaining mental health services. That's why we make it confidential. So they're balancing confidentiality with the third party need to know. The third party here was Tatiana's parents and loved ones. So they balanced the confidential nature of mental health communications and the necessity of obtaining mental health services. What does that have to do with confidentiality? Well, if people know it's confidential, they're going to go get help. If they know that they're going to be, their private stuff's going to be shared with everybody, then they're not going to go seek help. Less likely to seek help. So that's why confidentiality is there. So balance the rationale of confidentiality with the duty to warn, if any, third parties about future harm. And the court said, in part, we realized the open and confidential character of psychotherapeutic dialogue encourages patients to express threats of violence, few of which are ever executed. Because the psychologist said, listen, people tell me stuff all the time. And the American Psychological Association weighed in. The discipline in the profession said, we get this stuff all the time, this is create a nightmare. People say crazy, negative things all the time. Talk about hurting people all the time. They very rarely ever execute or act out on it. Okay, so the Supreme Court accept, this is California courts, by the way. The Supreme Court said, okay, we accept that. We get that. Certainly a therapist should not be encouraged to routinely reveal such threats. Okay? Such disclosures could seriously disrupt the patient's relationship with his therapist and with the persons threatened. To the contrary, the therapist's obligations to his patient require that he is not to disclose a confidence unless such disclosure is necessary to avert danger to other persons. And even though he must do so discreetly and in a fashion that would preserve the privacy of his patient to the fullest extent. So now you're cracking the door open a little bit in this case, right? You have to warn third parties, they say. So Tatiana's parents could go to court. And what they probably settled out of court, we never know what happened here. Okay, so that's the end of this case. But the reason why we look at Tarasoff is that was the first case in the United States of America that began to look at whether confidentiality was overridden by an obligation to warn third parties. And it was an awkward direction to go in, because how do you notify them? How do you judge whether it's credible or not? Real? It's going to be disruptive? You know, this happens all the time. But the California court said, sometimes you got to do this. Now, after that, you had a number of cases, okay, throughout America that began to flesh out the issues here and make it more concrete, the obligation. But the door was opened, and it wasn't getting closed anymore. You have to warn third parties in certain cases despite confidentiality. The more important case, another California case, was Thompson versus the County of Alameda. The California Supreme Court said that in the absence of a readily identifiable foreseeable victim, there was no duty to warn. However, if there was a readily identifiable foreseeable victim, there is a duty to warn now. Now, without figuring out what Tarasoff meant and what Alameda meant, I'm going to tell you where we are now. Here's the rule that arose out of Tarasoff and Alameda County. Okay? There is a duty to warn third parties, and it overrides confidentiality. Here's the basics of what has to happen. First of all, there has to be a threat of reasonably foreseeable and immediate harm. The harm has to be reasonably immediate. I'm going to use another word, imminent. It has to be imminent harm, and it has to be serious harm, grave harm. So imminent means it's likely to happen in the very near future. Grave or serious means murder, serious injury, catastrophic injury. Right. Two quick examples, just to flesh this out. I'm the patient. In 20 minutes, okay, that's pretty imminent if you ask me. In 20 minutes, when Suzanne is walking to the elevator, I'm going to go up to her, because I'm mad she didn't do her homework, I'm going to poke her in the arm. And I tell my therapist that. Immediacy? Yeah, I'm going to do it in 20 minutes. The other part of it is it has to be a readily identifiable victim. Well, we know who Suzanne is. I say who it is to my therapist, right? Readily identifiable victim. Immediate harm, right? Imminent harm. The harm has to be serious and grave. And there has to be a readily identifiable victim. And it has to be a credible threat. So let me start it all over. It has to be a credible threat of imminent, serious harm against a readily identifiable individual. I'll say it again. A credible threat of, I may have changed around a little bit, but it's a credible threat of serious, imminent harm against a readily identifiable victim. Credible threat, which means not God blowing off steam, right? That would be something that sounds like he's going to do it. Believable threat. A credible / believable threat of serious harm, serious and imminent harm against a readily identifiable victim. So if you made bullet points, credible threat, imminent, serious or grave harm, readily identifiable victim. That's where we are now. Credible threat, imminent, serious harm, readily identifiable victim. So, in 20 minutes, because I gave Suzanne a bad grade and she's mad at me, I'm going to go poke her in the arm by the elevator. Well, you all are my therapist, and you don't know me. I'm credible. Credible threat, imminent, 20 minutes, readily identifiable, you know who she is. It's not serious. Okay? On the anniversary, let's see, on the 100-year anniversary of the shooting of John F. Kennedy in 1963, which make it, 2163, I'm going to kill Jane Doe. Right? Obviously, serious harm, kill, 100 years from now is not imminent, right? It's got to be imminent. Conditional threats. If she does this again, I'm going to do X. That complicates matters, right? If that bitch does X or doesn't listen to me in class anymore, talking about Podar, I'm going to do X. That complicates things. But it has to be serious harm. It has to be imminent, readily identifiable. You know what? When I was in high school, every blonde girl I asked out rejected me. I'm going to kill a blonde in New York State next week. And I mean it. Credible, serious harm, no readily identifiable victim. So what are we going to do? What are we going to tell? New York State authorities, broadcast, hide the blondes?
So what happened if the person said that he was going to harm somebody on John Lennon's birthday, and the birthday date is tomorrow? You going to call the police?
Well, if it's imminent harm, that would be imminent. And serious, kill. And I don't know who the victim is, but if we know who the victim is, it fits. That's what you need to know about Tarasoff. Credible threat, serious harm, imminent, readily identifiable victim. That's where the cases took us in 2013. Yes?
Say said I'm gonna kill a blonde in New York State on John Lennon's birthday.
Okay.
And
We just
then-
gotta apply the bullet points. I don't make the rules, but go ahead.
And then John Lennon's birthday comes and the blonde is dead. Can they then tell the police?
We don't know.
Well, no, who's the next? See, here's why it's gotta be readily identifiable. What's the name of this exception? Hold on, what's the name of the exception? The exception is for, look at number 7. Who are you gonna warn?
Oh, it's not warning.
You know, Tarasoff was about telling Tatiana's parents. The purpose of this is if you're a therapist and somebody tells you about somebody that the patient's gonna kill, you may have a duty to tell their loved ones.
So if you know that your client already killed someone, you don't have to.
No, never have to tell about past crimes, ever.
Oh.
So what if you let all 3 points except the credibility part get into debate and
Well, you know what?
mentally unstable and they're bipolar, I mean, like, how?
I don't know, that's why the psychologist said, this is an art, it's not, it's not a science here, how do I evaluate credibility? Well, you guys do that all the time, you make those judgments all the time, psychiatrists, do it again. So what's gonna happen? You're gonna report it, I'm not gonna, if he says he's gonna kill so-and-so, credible, I'm gonna assume credible all the time. Now, you may have a patient who's, you're pretty confident nothing they say is credible. You may take a shot and not do anything, but, I don't know. The point is to know that confidential is not absolute, and that in certain situations, you may have, whoever you are, DIFUS worker, doctor, psychologist, nurse, teacher, you may have to warn third parties. That's what Tarasoff stands for. It's another exception to the confidentiality rule. Any questions about Tarasoff? Okay. Let me bring up a hypothetical that vexes many students. Imagine if you have a pregnant kid, and this happens periodically. Pregnant 15-year-old. She tells her social worker that the father, the baby that she's about to have, that the father's her 17-year-old stepbrother. Okay? And assume it's a reportable offense under mandatory reporting. The stepbrother doesn't live in the home full time. The teenage client, right? The 15-year-old, that's the client. You're the social worker, the client's the 15-year-old girl. She tells you the daddy's my brother, stepbrother, and I got syphilis. The student, client, teenager, pregnant girl does not want the social worker to tell the parents. Let me ask you this. Would it be fair or a reasonable thing for me to say all social workers would agree that the parents should not be told? Is this the easy one that everyone agrees don't tell the parents? No, it's pretty complicated, right? What would you do? I think this is one of your examples in the book that I copied. And it raises, and it brings up the STD to make things even worse, right? Third parties, right? Got a little third parties here. The boy may have the STD. He's sleeping with his own sister. Can't tell the parents. Mandatory reporting. It's all in there, it feels like, right? What would you do?
You're mandated to report it, but not to the parents.
You gotta report it to DIFUS, but do you report it to the parents? Their own son is sleeping with their daughter, and there's got syphilis in the house.
But there's also a duty to warn because okay, what if there's another child in the home or?
What if she says, and I really think this new kid is cute at school, and I'm gonna sleep with him next.
Oh, but
That's not.
but that's
What about parents? That's not serious? Okay, well,
It's not great.
what about if it's HIV?
yeah.
HIV ain't that serious anymore. It's serious, but it's not like we perceived it in the 90s.
You can call a hotline. There's an HIV hotline. And you can
Yeah,
call
but again, the question is tell her parents.
No.
So the parents would not be in a position to help a third party, the cute guy's Can he tell his parents?
Maybe we can have a conversation with him, like, you know, you really need to think about what you're going to do.
But
Can we advise the
don't
parents to take them for an extra appointment or something immediately? I mean, we're not telling them.
But the doctors don't have to tell the
The
parents.
doctor, yeah.
But there's no health worker.
You don't have to.
We should
So what we
just
gonna do?
encourage the girl to go.
Well, David.
But sometimes you get cases in the office where the parent, well, what you call it case? The mother had HIV, but then she was sleeping with two other men. One of them was a 70-year-old pimp, and then he got HIV. But we couldn't tell
You
him.
can't tell him that he got HIV tonight.
Exactly, you know, we couldn't tell him to go
No.
get tested, you know,
Mhm.
like nothing.
But you can call the HIV hotline and be anonymous, and I learned that in the Ryan White program.
And then they will call him and tell him?
Yep, yep, there is a HIV hotline in the state of New Jersey.
I didn't know that.
Mm-hmm.
What?
Look.
Yeah.
Sleep with
Yeah.
them.
Uh-huh, and you can. You don't have to say your own information, you gotta leave the information for the people, and there's they from the health department, and they will go out to who you identify.
Well, the health department can also do
Yeah.
that with syphilis, with STDs.
Yeah.
Okay, let me wrap up with a couple other issues.
What's the answer?
There's no answer to this. No answer. But it raises the issues, kind of ties them all together, and makes you think, right? Simply spouting these rules off, I want to think a little bit about it. Here's something else that happens sometimes. This is about ethics, and we talked about it at the beginning of the year, and I want you to pay attention to this, because I may ask a question similar to this on the exam. But when a therapist evaluates a client, it's never good practice to also be an expert witness. And we're going to talk about this. I'm transitioning into the expert witness stuff that I'll talk about next week. It's never a good idea to also be an expert witness in the case. And I'll tell you what case brought up these very issues. And I mentioned it earlier in the semester, but I want to reinforce it. She was accused of this, and I'm not sure how the facts unfolded. She's a brilliant woman. She's on faculty here, Dr. Eskelin. Dr. Sue Eskelin in the Glen Ridge rape case, which was a notorious case in the 90s where a bunch of boys from Glen Ridge who were on a football team together had isolated a developmentally and cognitively impaired 15-year-old in the basement, and they took turns having sex with her, and they penetrated her with objects. And one of the issues was she sexually assaulted? And that was what the prosecution was about. But also, was she sexually assaulted because she was forced? And another theory of liability was she sexually assaulted because she was so cognitively impaired that she was unable to give consent? There's two ways for these boys to have been criminally prosecuted. One is they forced her. That's an obvious sexual assault charge or rape, right? They force someone to have sex, that's rape. We talked about at the beginning of the semester, though, about free and affirmative permission and state in the interest of MTS, and any penetration without permission is force. So if she didn't give permission, that's rape, we'll call it, sexual assault. Or if she did give permission, was she so cognitively impaired, right? Sadly, our statute calls it mentally defective, like it's a product. We had to show, the prosecution in Essex County had to show she's mentally defective. We'll use the more modern language of cognitively impaired, that she was unable to give meaningful consent. So that was the issue, okay, in the case. And then, whether she said yes or no didn't matter. So if she was cognitively impaired and could not give consent, and they knew it, that's the last fact, they have to know it, right? Again, if you don't know, cognitive impairment, sometimes it's easy to spot, sometimes it's not. Some people seem rather normal functioning but they're not, until you get to know them a little bit. There's a good argument for getting to know someone before you have sex with them. So, in any event, was she cognitively impaired, so much so that she couldn't give consent, and did they know it? And the other one was, did they force her? Dr. Eskelin evaluated her for mental health treatment as a patient. Her parents hired her. And she evaluated her and said, okay, she's this, she needs that, she's got ego I'm making things up. She has self-esteem problems, she's got this, she needs to get this kind of treatment, she's got a little bit of this, a little bit of that. She diagnoses her and begins treating her. And the prosecution brought her in as an expert witness for the state to say, in my opinion, she is so cognitively impaired that she couldn't give meaningful consent. And that's where I said at the beginning of the school year, avoid those dual roles. There's no law against it, but it puts you in a very bad position. And you'll see why in greater detail when we meet next week and talk about expert witnesses, lay witnesses, regular witnesses, expert witnesses, and how people are cross-examined, how witnesses are challenged in the courtroom, okay? And you're setting yourself up for a challenge in the courtroom when you occupy dual roles. Because on the one hand, the clinician owes loyalty no matter what the truthfulness or lack of truthfulness is of the patient. She needs to evaluate and treat. On the other hand, she's supposed to come in and be totally objective, totally neutral, and give a clinical, sterile opinion about whether this girl was so cognitively impaired she couldn't give meaningful consent. And that puts the expert witness in that situation in a very, very difficult posture in the courtroom. Okay? And so one must be very careful, and I recommend don't do it. Very careful when you conduct a private forensic or psychological evaluation and then become an expert for either the prosecution or defense or anybody else in the courtroom. That's something that you want to be very mindful of. And it will be an issue on cross-examination, and I will tell you even more about that when we meet next week. Any questions about what we talked about tonight? Let me just see if there's something I want to remind you of that we did not talk about. Because I want to make sure you guys are totally prepped for the final. Oh, you guys are prepped. I'm feeling it. I mentioned the excited utterance before. Remember I said about the referral? Maybe in the referral is a statement by the mother, oh, my husband's burning my daughter right now. That would be an excited utterance, arguably. And an excited utterance, it has to have happened. You know, if someone ran in here and goes, oh my God, someone stabbed somebody in the cafeteria, a guy with a hat on and a long white t-shirt, he stabbed this woman in the cafeteria, and they're shaking and nervous and their voice is high, all the things we look at to demonstrate excitement. We concluded that those statements can come in as an exception to hearsay because they're considered more reliable because people don't have a lot of time to lie or misrepresent or formulate whatever. But usually the startling event has to be at or near the time of the statement. But it can be up to a week sometimes. In child abuse cases, courts have even expanded it to a month, or sometimes many years later if it's what they call rekindled excitement. But generally speaking, it has to be at or near the time that the incident occurred, but it can be expanded sometimes, depending upon the nature of the events. Okay? Okay, I'll see you guys here next Monday.